in order to get picked up for Zoom, just make sure you're by a mic. There's no table mic, so if anyone asks a question, you can either pass the mic or repeat it. Yeah, and then the mics are, if you pass those around, just put it for the green, and then it's fine. Oh, and did he bring a clicker? Yes, a clicker. Oh, you have the clicker. Okay, great. Okay. Okay, I think we're going to get started. We want to keep everything on time. So for those of you I haven't met before, I'm Ashley Huebner. I'm one of the pro bono counsels here in the Chicago office. I'm really excited to see you all here today. I know it's weird with the day off yesterday and people working in different places, so I appreciate you all being here in person. I know yesterday might not have actually been a day off for some of you, but we appreciate you making the time. The work you're doing today really makes a huge impact. You are going to be assisting 10 kids who, as a result of your work, will be able to petition for immigration status that will give them protection from deportation, access to a work permit, access to a driver's license, eventually access to a green card and citizenship. So a lot of the things, these are teenagers, a lot of the things that you think about as you're becoming a teenager, getting a driver's license, going to college, these things are not necessarily available to these kids until they are able to pursue this form of status that you are helping them with. So it really, really makes a huge difference. I also just want to thank you all for coming out because it's been really great at Kirkland to have this ongoing project with the restructuring group to work on these specific cases. So we did our first SIJS predicate order workshop in the spring of 2022 with NIJC and CVLS, and it was a great success. All of those kids got their predicate orders and are on the process of getting their green cards and have work permits and all those great things. Since that time, a number of other attorneys in your group have continued to work on these cases on a one-off, and now you're coming back again for another workshop. And so I really want to encourage you all to really crowdsource your knowledge and your resources here. Obviously, you're going to have a great set of support from NIJC and CVLS on the technical side of things here. You can always reach out to me as well, but also reach out to your colleagues. You know, if you're running into a particular issue with a client or you have some questions or you're looking for something that worked well in another case, please reach out to this group and utilize each other as you move things forward. After we break for lunch, we're going to be separating out to meet with the individual clients and have the individual attorney team meetings. We'll let you know where you're going then and give you some additional logistical information at that time. So without further ado, I'm going to turn things over to NIJC.
Thank you very much. Hello and welcome again. Great morning. It's not very hot, so that's pretty good. I am Berenice Sanchez. I am the SIJS Pro Bono Coordinator for the NDK team, so the non-detained kids. And then today we have Hillary Richardson, who is our Managing Attorney, Dominique Mejia, who is our IG Works Fellow. It's like a tricky word. And then we have Rob, who is a special guest today for CVLS, who has more experience on predicate orders today. And before we get started, our nice pictures up here. And we do have a QR code in the next slide. Please take out your phone so that we know who's here and you can sign in. And that way you can get CLE credit for Illinois attorneys. I will be providing 2 CLE codes throughout the presentation, and there will be another CLE code towards the end. That way you can get your certificate via online. And there is ethics credit for this presentation. So that's pretty cool. Yeah, I'll give everybody a second.
Even if you don't plan to get the other students, please do it again so that we can think it.
Yes. All right, yeah. So thank you so much. And CVLS, NIJC, and clients are very grateful for your partnership today, as these clients have traveled around 2 hours to get here today. Some families did get here earlier, but I told them go get breakfast and then you'll meet your attorneys later. And a little bit more about ourselves. We do have a partnership of over 1,600 pro bonos, and that the number keeps growing every day. We do represent more than 10,000 clients. That's our general, right? And you will represent these families in litigation, federal agencies, and we do go into litigation and we advocate for these children and other immigrants, refugees, and asylum seekers. And we provide that through advocacy and public education. Here's a chart on how we move our clients along. So when a client comes to us, we do an in-depth interview. And once we do see a relief for them, we sign a retainer and then we look for a pro bono for them. And then once you guys accept the case as pro bonos, we are there for you along the way and throughout the life of the case. So you're not alone in this process. Next slide. All right, and this, I am a visual learner, so here's a list of responsibilities of all parties. NIJC will provide you with general trainings, technical advice. We will review your draft before you file anything. We'll give you case strategies, policy updates if anything happens. As an attorney, pro bono attorney, you're responsible for providing interpreters and communicating with your client, especially since this is a vulnerable age for them. It's really important to communicate with the parents and the child. And you'll be representing the child and federal agencies in this case, state court. And then clients are responsible for letting you know about their stories, any updates in their lives, and just being responsible of keeping that communication with you. And then why are we here today? So this is really important because we're providing this layer of protection against deportation for these children. And this will just give them a step to stability. Many of these kids have been struggling or they can't apply for college. That's like a foreseeable problem. So this is something where they can get a work permit and a social security number, and that will be amazing for them in their future. And then as for today, you'll learn about SIJS. If you've never done SIJS cases, can I get a raise of hands of who has done SIJS cases or any other immigration relief? Awesome, I see a couple hands. Thank you so much for those. And so this is a great opportunity to learn more about SIJS and the predicate orders. And it's just like nothing that you see normally, since you're not involved in the immigration process, you're involved in the state court process. And it's necessary today to sign all forms, so that way you have established communication with the client. And post-clinic, we'll go through a list of what are your responsibilities after. So we do plan to have you guys finish these cases within 6 months. And then if that's before, like that would be great. And then stay in touch with your technical support. So that would be Hillary and Dominique and Rob. Those are your technical support. And I'm just a coordinator. So if you need access to your documents again, or you have questions about the handouts, let me know. All right, so now I'll pass it to my colleague, Dominique.
Good morning, everybody. My name is Dominique. I'm an Equal Justice Works Fellow and Staff Attorney at the NIJC. So I'm here going to provide an overview about what Special Immigrant Juvenile Status is. So Special Immigrant Juvenile Status, also known as SIJS by its initials, is a form of immigration relief available to immigrant children who have suffered abuse, neglect, or abandonment by one or both of their parents. It's available to immigrant children who are living in the United States, and the benefits come with protection from deportation, and it leads to permanent residency or a green card in the future, and eventually citizenship. One big caveat of this form of relief is that children, even if they become citizens or legal permanent residents, they would never be able to petition for their parent. The reason being that Congress enacted this protection against vulnerable children, but wanted to make sure that one parent wasn't pitting one parent against the other to be able to eventually get this benefit. And if anybody likes to look up statutory authority and just kind of look up the background, we have this. It's a federal laws. It's under INA section 101A27J, the regulations and USCIS guidance. It's not necessary for you guys to look it up, but in case something really, really weird comes up and you're interested or want to go into a deep hole, we provide these information for you. Going into the statutory requirements as to what makes a child eligible for SIJS, they have to be under 21 years of age. They have to be unmarried. They have to be physically present in the US, and a juvenile court has to declare the child dependent or placed under the custody of a state agency, department, individual, or entity. and determined that the child's reunification with one or both parents is not viable due to abuse, neglect, or abandonment, or a similar basis under state law, and determined that it's not in the child's best interest to return to their home country. And then there's a kind of like the Secretary of Homeland Security has to consent, but very often that's not an issue. But you guys are helping us with that juvenile court aspect of making sure that child is eligible for SIJS. So juvenile court is defined as any court with jurisdiction under state law to make judicial determinations about the custody and care of juveniles. In Illinois, that counts as domestic relations, parentage court, guardianship, adoption, juvenile delinquency, and child welfare courts. Typically, a juvenile court order must be entered before the child turns 18, but in 2021, a change in Illinois law has expanded coverage to children under 21 for those that are seeking SIJS findings. So if anybody has worked in family law, you might be kind of hesitant as to, how is this still juvenile or possible for minors or persons that are no longer considered minors, but for the technical sense, if they are under 21. Okay, so SIJS is a 3-step process. So first is obtaining that juvenile court order. And so all of you guys here today are helping us with that first big step. And usually this is the biggest hurdle for families and for eligible children because this involves going into a family court. So all of us, NIJC here, we're immigration attorneys. This is what we specialize in. Although we have some experience in state court, this is something that we really is not our bread and butter. And so that's why we partner with CDLS and we partner with our pro bono partners to kind of help facilitate that big hurdle, getting over that big hurdle. The second step is filing that court order with the immigration petition and submitting that to USCIS, which is United States Citizenship and Immigration Services. If they are then approved, they then could apply for adjustment of status, which is the green card process. So this is, again, we like to be visual learners, just having different ways of communicating information. So if you want to see a timeline, so it's first obtaining the SIJS predicate order, file the petition before the child turns 21. And if approved, the client then receives deferred action, and we'll go into detail about what deferred action is, but it's essentially protection from deportation and getting a work permit. And then they have to wait about 5 years right now after being approved for them to then apply to become a permanent resident. If they are approved, they become an LPR, and then in the future, they could become a US citizen. So this is a really, really long process. But we're so grateful for you guys to help us with this big hurdle in the beginning. Okay, so this is the history of SIJS in Illinois. Again, if you want to go back into the history of SIJS, so it first started in the Immigration Act of 1990. It created SIJS for children declared dependent on juvenile court and required that children be eligible for long-term foster care. In Illinois, it incorporated in 2003, incorporated the SIJS language into the Juvenile Court Act only, and included dependency and long-term foster care requirements. So that made a very narrow window of children who were eligible. So those who were declared dependent by the court and who were taken out of their parents' care. The TVPRA of 2008 is what created multiple amendments and created the modern SIJS. So it removes the long-term foster care requirement and allows children to petition for SIJS based on harm by only one parent. In Illinois in 2019, we updated the Illinois language to remove the long-term foster care and dependency requirements, incorporated SIJS language into all relevant laws. So before it was only the Juvenile Court Act, now it's in the Illinois Marriage and Dissolution Act, guardianship, adoption, all these other courts that we mentioned previously. And then lastly, and the most significant update was in 2021, when it conformed Illinois law to federal law to ensure protection for all SIJS eligible youth up to the age of 21. No worries. Going into the law in 2019, again, it amended 6 Illinois laws listed there. And one significant change is that previous to 2019, although children were eligible, one of actually our biggest hurdles in getting these orders is actually the judges themselves. So depending on the judge, it could be political reasons. It could be that they did not want to give an immigration benefit to a child. They didn't want to declare that somebody was not in their best interest to be returned to their home country. Or on the jurisdiction side, a lot of judges thought that, I only do family court, I only do state law. I don't have the jurisdiction or the authority to convey an immigration benefit onto a child. So the update in 2019 is that it requires judges to enter SIJS findings if supported by the evidence. And so this might be key for a lot of you actually, because Cook County judges are very well informed about SIJS, but some of you guys actually have cases that will be in the collar counties. We've had experience in the past. We've gotten predicate orders in those counties, but there's a lot of judges in those counties. So some judges may not be as informed. So if you run up into a judge who may not know, you just can direct them to Public Act 101-121 and say, Judge, if the findings are here, if the facts are here, you have to enter this order to provide this child eligibility for SIJS. Okay. Key point also is that abandonment now includes where one or both parents have died or cannot be found. And we'll go into detail about those definitions in the next slide. Okay. Here are the specific citations to define abuse, abandonment, and neglect, depending on the type of case. The majority of you will be in the Illinois Marriage and Dissolution of Marriage Act. So I would highlight that or make a little star. You should always be citing to that one if it pertains to you. I believe everybody should be under there or the Illinois Parentage Act. There should not be any guardianship or child welfare or adoption cases today. So defining abuse. So abuse under Illinois law means physical abuse, harassment, intimidation of a dependent, interference with personal liberty, or willful deprivation, but does not include reasonable direction of a minor child by a parent or person in loco parentis. So what does this mean? If a parent is, a child has done something wrong, a parent is telling them, this is something wrong that you've done, I'm going to take your cell phone away. Is that abuse? No, right? Now, if we incorporate corporal punishment or punishment that is extreme, threats of violence, actual harm, physical harm, things such as that can amount to abuse, right? Something that I want to note includes that abuse if a child witnesses a parent also being abused by the other parent, that also counts as abuse under Illinois law. So domestic violence has a big impact on families, especially on vulnerable children, children of a young age. And so if that is in your case, I would note that as abuse as well. Okay. Abandonment includes, but is not limited to, the failure of a parent to maintain a reasonable degree of interest, concern, or responsibility for the welfare of the minor, or when one or both of the minor's parents are deceased or cannot be reasonably located. So a number of your cases have parents who have either disappeared entirely or will call in once every 5 years, right? So that is considered abandonment because there is no reasonable degree of interest or concern for that child, right? There, I believe, is one or two parents that is also deceased under Illinois law that also qualifies as abandonment. Okay. Does anybody have any questions so far? Feel free to ask questions during as well. Yeah.
So my email that I would click on this said that the parent is holding the children and just trying to get custody of them. How does that fit?
So it's one or both. So your case facts, your case summary is most likely that the dad is not in the picture. And so he may have abused, abandoned, or neglected one or more of the children. So we'll have to go into the case facts of that. So it's fine if it's only been one person who was abusive. It doesn't have to be both. Okay.
But does this ultimately result in the other parent gaining custody in some way?
Yes, yes, yes. Yeah. So a lot of our kids actually have been with their parents that they have, the good parent, we'll say. And so they've always been with this parent. And so some judges, or in this case, you might be kind of asking, why do we need an order to kind of outline why this parent deserves to have this child in their custody, right? It's for legal matters, right? When you go to the doctor, when you go to school, when you go to enroll, basic reasons why you would need a court order, why you don't need the other parent's permission. If the child wants to travel, right? And if you want to travel outside the country, you have to get a passport. If that parent is not there, that child can't get a passport, right? So things that's for basic reasons, medical reasons, but also for legal and immigration reasons. So if we need, this child needs a benefit and they're eligible for deportation or removal, and we want to make sure that they have those protections. The last one is neglect. So it's not receiving the proper or necessary support, education as required by law, or medical or other remedial care recognized under state law as a necessary for a minor's well-being. So including adequate food, clothing, and shelter, or who has abandoned by his or her parents or parents. So if you have a parent who has abandoned that child, you can also say that they have neglected that child because they have not provided for that child in their absence. Okay, neglect. If a child has contact with their parent every other year, but in that every other year they're not provided with support, financial, food, expenses for medical care, that is also considered neglect. Any questions? Okay, so who is impacted? So we have an example here of Carlos, age 8, from Honduras. So Carlos came to the United States with his mother after his father was murdered when he was only 3 years old. He had no one left to care for him in Honduras. And because of the 2019 change in Illinois law, which expanded that definition of abandonment to include one or both of his parents is deceased, Carlos was able to secure a predicate order and apply for SIJS protecting him from deportation. Okay. So this one is a slightly trick question. It says here that we got him SIJS based on abandonment, but can anybody else add another definition, other means for which he would be eligible for? Or any red flags, perhaps? Okay. We're a quiet bunch today, it's okay. Neglect, right? So if the father didn't provide a means to provide for that child before his death, that could also be considered neglect, right? In some instances, not all, before the parent passed away, there may have also been instances of abuse. So we want you guys to kind of investigate that. So we did our best to intake the child and the parent to kind of get the facts of the case, but in your communication with the client, it may come out that actually prior to their death, they were also abusive, or they were neglectful, or it wasn't the first time they had abandoned them. And so although we only need one basis to enter SIJS findings, the more bases, if there are there, the stronger the case is for the child. Questions? Okay, then we have Jenny, who's age 16 from Guatemala. So Jenny's father was an alcoholic who physically abused her mother. When Jenny was 13, her mother fled the abuse and came to the US, leaving Jenny with her grandmother. Jenny's father saw her occasionally, but was often drunk and never provided for her. When Jenny's grandmother became too sick to care for her, Jenny came to the US to reunite with her mother. Jenny's mother was able to file a petition for sole custody and get an order with SIJS findings showing that Jenny could not be reunified with her father due to his neglect. Okay. Anybody see anything missing in this one? So the first line, so her father was an alcoholic who physically abused her mother. Okay. If the physical abuse was in front of the child, that also is considered abuse of the child. The reasons being is that domestic violence, as many of us know, has a big impact on children. It's a cycle, and witnessing physical abuse in that sense, or any sense, is very impactful to a child and can affect them long-term. So under Illinois law, domestic violence or domestic violence witnessed by a child is also considered abuse. So we would have also liked to have added neglect and abandonment to this one. Okay, great. So previously I talked about how SIJS is a 3-step process. We looked at the timeline. And one of the biggest kind of holdups after the predicate order is actually once they are approved and they're waiting to become legal permanent residents. And the holdup is actually in them having a visa in their hand, so the actual ticket to then become legal permanent residents. And that is the visa bulletin. So this is a visa category, and there's currently a wait about 4 to 5 years. Okay? We want you to know this just generally for general information about SIJS, but your clients may also ask you, like they may be very excited, and they are very excited to meet you guys today, and they're going to be like, great. After working with my attorney for the next 2-3 months, my child is going to have protection, and then they're going to become a legal permanent residence, and everything is solved and everything's good. And generally, yes, you by helping us stay, you're going to kind of put a stop and protection against against deportation or removal, but it's not something permanent yet. Okay, so here is kind of the information if that comes up, but there's about a 4 to 5 year wait. Currently, the government is processing applications from January of 2021 for legal permanent residency. Okay, so going back to the steps, getting a predicate order in state court, filing that with USCIS with the immigration. If they are approved, since about last fall, we started receiving approval notices that also had deferred action and grants for work permits. So deferred action is an act of prosecutorial discretion that defers proceedings to remove a non-citizen from the US for a certain period. Deferred action does not provide lawful status, but it does allow those with deferred action to obtain employment authorization. So a lot of you may know deferred action from DACA or Dreamers in the news. Deferred action is just a sense, is a category. There's actually a lot of different people that are eligible for deferred action, but essentially is a pause in removal defense. So some of your clients are in immigration or removal proceedings, and so that's why it's urgent for us to kind of get this filed within the next 6 months because of the elections coming up. Changes in administration usually actually can come, policies can change, especially not always, but sometimes for some of our older children, our older clients that are going to age out, they're going to be 18. Children that are under 18 tend to be kind of glossed over for deportation or as priority, but those over 18 can be put on a priority list for removal. So this is why we mentioned this and why we want to have that deferred action as soon as possible. Being granted deferred action can be a basis for terminating removal proceedings. That is handled on the NIJC side, the immigration side, but it's just kind of an explanation. And after being approved for SIJS, deferred action, the child is eligible to apply for a work permit immediately. And that work permit lasts during the period that they're waiting to become residents. Okay. Any questions so far? Yes, back. Yeah.
Yeah. Sorry.
Sorry, can you elaborate on the first requirement for a juvenile court?
This
Do we
category.
need to, it sounds like you're saying, okay, the custody can stay with one parent. Like we don't have to show that both parents have abandoned the child, but how does that square with the first requirement?
So to place them under the custody of a state agency, department, or individual or entity. So the court is placing them dependent on that parent petitioning the court. So you are representing that parent. Yes, everybody has a parent here. Most of them are moms. So you're asking the court to declare them dependent on mom. Place them under the custody of mom. Okay. Yeah. So we consider custody as having the child physically in their care, but legally you're putting them custody in their care now through the courts. Does that clear that up?
You have to prove that like the abandonment, because your first point was this isn't meant to be a basis for like custody disputes when you have two parents that are like otherwise they care for the children. Like that's how this is for.
No. So yes, so we've screened everybody here. We screened all the clients, all of the parents. This is going to be a what's the word? Uncontested matter, default matter. So all of the cases here are moms, and then all of the dads are in home country. I believe the majority, except for one possibly, is maybe in the US, but he hasn't had contact with a child in 10 years. But so they're all uncontested. They're all in a separate country. We are in these custody orders. We're not asking for child support. We're not asking for alimony. We're not asking for things that would actually constitute kind of going into court and negotiating. We're not negotiating, like trying to. It's uncontested because there isn't anything that the judge would have to kind of figure out equal parts of it. It's who has the child physically and who has had the child physically, and for the reasons being the abandonment, abuse, or neglect. Yeah. Good questions. Any other questions? Okay, great. So then I'm going to skip back to the last slide. And up next is, I believe, Hillary. So Hillary and Rob are going to go over the predicate order state court process. You want to click your hands?
Hey, good morning, everybody. My name is Hillary Richardson. I'm the managing attorney of the non-detained kids team at NIJC, and I just want to echo my colleagues. Thanks for being here. We're really excited to have you all help us with this process. So I've been hearing some questions that relate to custody versus the immigration piece, right? And fear not, that is what we are about to go into. We have our family law expert from Chicago Volunteer Legal Services here, Rob Zielinski. He and I are going to tag team a little bit the next section. So to clarify once again, what you all are going to be helping us with is a piece of the immigration case, but your part is going to be in family court. It is necessary to get this custody order in order for us, the immigration attorneys, to help these kids get protection from deportation. But you all will not be filing anything with immigration. You won't be going to immigration court. You'll be going to family court. All of your cases are custody cases, and as Dominique explained, they should all be default, uncontested cases where all that you're seeking is an order of custody and then these special findings. We are not sending you in to family court to do a custody battle. That is a whole separate thing. You can talk to CVLS if that sounds fun to you. But for these, we expect them to be procedurally straightforward and relatively easy to complete. So we're going to move a little bit to talk about the process to obtain this predicate order. So it's called a predicate order because it is necessary before we can start the immigration case. So all of you today have been assigned to a client, and you will meet with your client today. So we're really excited to kind of do this warm handoff so that you can start the process right away, meet with your client, and we'll talk a little bit about the steps that you'll be reviewing with the client today. So first, you'll be reviewing your case file so that you have an idea of what your case is about. And then you'll meet with your client and get any signature pages today that you might need as you work up your petition later on. You're then going to draft and file your petition for custody. We have checklists with the extensive detail about what needs to be in that petition, and we'll be reviewing that with you. After you file your petition in the court, the next step will be service of process on the respondent, who, as Dominique mentioned, in this case is all fathers. And we'll talk about different forms of service of process. And then once service has been completed, you will move forward to your final hearings. You'll be asking that the respondent be defaulted because we don't expect the respondents to respond or contest these cases in any way. So you'll schedule your final hearing. You'll work with your client to prepare their testimony for the final hearing. And then if all goes well, the judge will enter the final order of custody with SIJS findings. And then your work will be done. You'll hand that over to us. We will file the children's immigration petitions, and hopefully within a matter of months, we'll be able to get them approved for SIJS and deferred action, which can provide them some level of protection and put them on a path to citizenship. So I'm going to go over a couple of these beginning slides about meeting with the client before Rob gets into more details about the process for custody. So to be clear, again, today your client is the petitioning parent. Okay, this is to the benefit of the children, and the children are our clients and NIJC's clients, but your client today is the one who's filing the petition. So that's mom in, I believe, all of your cases. She will be filing a petition for custody. You are welcome to meet with the child separately if there's information that you want to obtain from the child, but for the most part, you will be meeting with mom. You'll be treating mom as any other client, meaning you want to preserve confidentiality and privilege of attorney-client information. So to the extent it's necessary to ask additional questions of mom, you want to make sure that she's in a private and confidential environment to do that. We do want to be conscious of the fact that if there's kids here, we're not going to be talking extensively about abuse and neglect in front of the children. So use your best judgment on that. You also, these are some baseline procedures, but I just want to highlight them so that we have them top of mind before meeting with the clients. But you obviously want to review all of the information with your client before filing in court. We've already met with these clients and screened them. We've given you a great deal of information. So in theory, you could just draft a petition and file it, That would be bad practice and unethical, right? You want to meet with your client, make sure everything in that is true, and make sure they're ready to sign off on that before you file it in court. You also want to make sure that you are working with an interpreter wherever necessary. Some clients have different levels of English, right? They might have some English, but if you want to be moving forward in the client's best language, you're not going to be muddling through to try to get some basic information. We want to make sure that everybody today comprehends fully what's going on. And we'll have Berenice will talk a little bit more about tips for working with interpreters to make sure that the meetings are as efficient as possible. And then finally, you want to discuss risks with family members before they file in state court. I want to highlight this because NIJC has spoken with these family members as well. We often get the question, especially if a parent is undocumented, well, is it going to hurt me? Is it safe for me to go into a state court? The answer to that, especially for right now, is yes. Okay. There is always going to be a risk as an undocumented person in the United States, right? There's always just the risk of immigration enforcement. That being said, all residents have the right to access the courts. In Illinois, we have undocumented folks accessing courts for different reasons for all kinds of cases every day. Fortunately, we have some protections in place that say that ICE can't just like go into a courthouse and start asking people their immigration status. So going into court as an undocumented parent to file for custody of your children is not only necessary and important for your family, it is about as safe as it can be without making guarantees. We don't make guarantees, we're lawyers, right? We always say, it depends on something. So you are welcome to review that with your client if they ask. If they have more questions that get more into the details of their immigration status, please feel free to refer them back to us because we'll be able to provide them a little bit more detailed information. You can inform the client your job is simply this custody matter. Questions about that? All right, so this is our initial slide. What kind of case do I file? I think it's become clear it's a custody case. Today, these are all custody cases, which means we can go into a great deal of detail about the procedures in your case without having to worry about the other types of cases. I want to highlight the statute talks about findings of dependent on the court or custody. In this case, we don't need a finding of dependency on the court. That is a separate prong of the statute that we won't be working under today. All that we're trying to do today is obtain a final judgment of custody or allocation of parental responsibilities, which is what this is now known as in Illinois. And with that, I'm going to turn it over to our family law expert, Rob, who will talk about allocation of parental responsibilities.
Thanks, Hillary. Thank you all for coming today. My name is Rob Zielinski. I'm an attorney at Chicago Volunteer Legal Services. I've been practicing family law for a long time, and I don't know if that necessarily makes me an expert, but I hope to at least instill a little bit of knowledge in you. Effective 2016, we stopped using the words custody and visitation in Illinois. We still use it because it's easier to say than the allocation of parental responsibilities and allocation of parenting time. So you will hear family law attorneys and non-family law attorneys use the words custody and visitation to this day. But typically, parents are filing allocation of parental responsibilities cases. There are two things that the court is concerned about in custody cases, and that is one, the allocation of parental responsibilities, and two, the allocation of parenting time. In 2015 and earlier, the legislature decided that custody was a little bit too vague. We wanted to maybe specify things a little bit. So we're talking about not only where the child resides with which parent, but also what kind of decision-making responsibility each parent has. So in the eyes of Illinois, parents do one of four things. They manage the child's education, they manage the child's medical care, they manage the child's religion, and they manage the child's extracurricular activities. That's all that parents do, apparently. We know that's not true, but in the eyes of the court is looking for you, the attorney handling the custody case, to present a final order that addresses decision-making in each one of these four aspects, and also the allocation of parenting time, meaning physically where does the child reside. Since these are default cases and the fathers aren't participating, you're going to be reserving the issue of parenting time because there's not going to be any parenting time awarded to the father. So really what you're looking for is an order that gives mom majority parenting time or primary parenting time, and then grants her all of the decision-making responsibilities exclusively. At CVLS, we handle all different sorts of family law cases. Maybe this slide should be titled, "What kind of petition do I file?" Because these are all custody cases, but I don't know if the clients that you're meeting with today involve married parents, but if they were married, you could file a petition for dissolution of marriage, which gets the parties divorced and also addresses 4 other issues: allocation, child support, maintenance, and property division. You can file a petition for legal separation, which would address all of those issues, but keep the parties married if they were wanting to do that. But we're focusing on this third bullet here, the petition for allocation of parental responsibilities, which allows the court to address issues of allocation, meaning custody and visitation, and child support. Doesn't address any other issues. If the parties are unmarried, which all of these cases are, then you've got 2 options. You can file a petition for parentage, which addresses 3 things: paternity, allocation of parental responsibilities and time, and child support, or you can file a petition for allocation of parental responsibilities, which addresses allocation and child support when paternity has already been established. So we're going to be talking about this a little later on in the presentation, but there needs to be some legal relationship between dad and child. And if the dad is already on the birth certificate, then you go ahead and file your petition for allocation without having to address that issue. But if dad's not on the birth certificate and has not previously been found to be the legal father, then that might be something to address in your petition and will need to be addressed in your petition before you get a final order. There is a possibility for non-parents to file for allocation of parental responsibilities in the Domestic Relations Division. None of these cases are that. In the past, we do have 1 judge that presides over all of the minor guardianship cases in the probate division, and that judge was not friendly to SIJS cases. That's since changed. So we did historically see a lot of non-parent allocation of parental responsibilities cases, but we don't anymore. If you had a non-parent case, you'd have to deal with the issue of standing, which you don't have to do because you don't have any non-parent allocation cases. So drafting the petition is going to be your first step after meeting with the client. We have samples for what your petition for allocation of parental responsibilities will look like. Generally speaking, as with any complaint, you're going to be alleging facts and then you're going to be requesting relief. You're going to be identifying the parties, mom, dad, identifying the child, identifying the legal relationship among them. But then you're also going to be alleging facts that can support your request for a finding that the child has been abused or neglected or abandoned, and that it's not in the child's best interest to return to their home country. In addition to the standard requests for relief that are going to be in these petitions, like I want mom to have sole allocation of parental responsibilities and primary parenting time, you're also going to be asking for SIJS findings. And then you'll also want to avoid any mention of the parent or sponsor's non-parent's involvement in the child's journey to the United States. After you've drafted your petition, you'll send it to NIJC or to us, and we'll review it prior to you filing. I think, Hillary, you were going to talk about the magic language that needs to be in these.
Yeah, I'm gonna hop in and take over for the SIJS piece. Question so far about what Rob has explained about the custody. There will be questions, don't worry. Okay, so the magic language is the piece of this case that is required. That is the most important for SIJS purposes. And that needs to be included in the petition, and then it will be included in your final order. And that is what's going to allow us to take this final judgment and help the child apply for SIJS. So this magic language reflects the INA, the immigration statute, and it needs to be really exact because the people over at USCIS are quite literal. So saying reunification with parents is not is not feasible, or reunification with the parent is not going to happen, or reunification with the parent is not a good idea, none of that is going to be sufficient. It literally has to say reunification not viable. Please don't get creative with your wording on this one. We have fought long battles with USCIS about a slight difference in wording that means the same thing, and we just don't want to do that. So we've got the magic language. It needs to be exact. So in your case, it will be reunification with the father. That is the case in every one of your case files. And ideally, you would put the person's name in there as well. So reunification is not viable due to whichever one of these factors or multiple one of these factors is applicable in your case. Don't just do abuse / neglect / abandonment. You do want to say which one, pursuant to whichever legal definition under Illinois state law applies. They are all under the general section of the Illinois Marriage and Dissolution of Marriage Act. The citations are in this slide and they're in your templates. We highly recommend that you go look at the statute. Just do a quick Google and look at that section of the statute and read it so that you know what you're citing to and so that you know what the appropriate way to include that citation is. But that is the essential language that will be in your petition, as well as it will not be in the child's best interest to return to their home country. Okay, and you will, in your final judgment, be providing a brief reason for that as well. So this is my slide, right? This is your slide. All right. So this is the way that you're going to frame that. This is just an example so that you can see about what level of detail is appropriate. You're saying respondent neglected the minor children by failing to perform caretaking functions. This is old. Is this old? Yeah. So we're going to update this definition, but these are the specifics that support your allegation of neglect. They failed to provide food and shelter. They've had no relationship with the minor since the minor was 3 years old. And maybe one more bullet point and you're done. You do not need to outline the parent-child's entire story in your petition, but you do want to allege facts sufficient in order to support that finding. So we're going to move on to establishing paternity, which Rob mentioned previously. That won't be applicable in all cases. It should be highlighted in your case file if this applies to you.
So we're really talking about whether or not there's been a legal relationship established between dad and the minor child. Typically, when a child is born, at least in the United States, the mother gives birth to the child and is automatically listed as the child's mother. It's rare, but in certain cases it does happen where a mom's not on the birth certificate. But generally, we're talking about a case where mom's on the birth certificate and there is no father listed on the birth certificate. If that's the case, then as part of your petition, you have to allege a father and then establish parentage as part of your case. There are 3 ways in Illinois that one can become a legal dad. You can be married to the mother at a certain period of time before the birth of the child or at the birth of the child. There's a presumption in Illinois that if the husband is married to the mother at the time of the birth of the child, then the husband is the father, and that presumption can only be overcome with the use of a specific form. The other way that you can become a legal dad is by signing a voluntary acknowledgement of paternity. So if the parties aren't married, but dad's at the hospital during the birth of the child, he's typically presented with something called a VAP, a voluntary acknowledgement of paternity form, and he signs that, and then later through an administrative process ends up on the child's birth certificate. If neither of the first two happen, then you can petition the court to establish the biological father as the legal father by filing a case and serving that person, and then either through agreement or by genetic testing if the father participates in the case, or by default if he doesn't, find him to be the legal father. Know that personal jurisdiction over the father is needed for a court to make a paternity finding. Some judges may have an issue if you ask the court to make a parentage finding based only on publication service. We're going to talk about service of process in a little bit, but Most of these cases will be publication cases, given that the fathers are going to be residing in another country.
So if his name's on the birth certificate, which category?
So if he's on the birth certificate, he's already the legal father. I don't know if in that home country they have a voluntary acknowledgement of paternity or if they just sign the birth certificate right away, but that makes him the legal father. Yeah. Any other questions? All right, so I think this is Hillary's slide, but a lot of these cases, some of these cases are non-Cook County cases. The procedure that I'm talking about today is going to largely be about Cook County cases because that's where I have expertise. So the law will apply, but not necessarily the procedure. So make sure to contact the court clerk in the county where you're filing your case if it's a case other than Cook. But I know that NIJC has experience in those collar counties too.
Yeah, and I just wanted to hop in and say, we actually have a decent size of group of cases that are in Will County. We have done maybe 1 or 2 cases in Will County before with other pro bono partners. So we will do our best to provide you with what we believe are the most updated procedures. That being said, we're going to encourage you to work with your colleagues to reach out to the courts locally to ensure that you are following the most updated procedures for your Will County courtroom. It is possible that there will be only one judge hearing all of these Will County cases. The courts are much smaller in the collar counties. So just keep that in mind. But we'll provide the same amount of support on the law, but we'll be relying on you a little bit more in terms of following up about those procedures.
And this is also where Calendar Court will be a big help to you. So Calendar Court is used to helping file with these types of cases, and they can reach out as well and assist in this process. So definitely utilize them as well.
Don't fear. This is going to be great. You're going to do great.
That's what I was telling myself before this presentation. This is going to be great. You're going to do great. So you're taking these cases in partnership with NIJC and CVLS. We are civil legal services providers, meaning that all of our clients are entitled to an automatic waiver of fees called CLSP. You're going to be using a form. You're going to be drafting a document called a CLSP that waives all of the costs of filing, appearing, and transcripts, etc. It's nice because otherwise, if you're just a pro se or self-represented person, you have to appear before the court and ask for your fees to be waived. But by taking cases with a civil legal services provider, all you do is file a form and all your fees are waived. E-filing is mandatory in Illinois civil courts. You can visit this website on this slide for more information about e-filing. CVLS on our website, cvls.org, has tutorials on e-filing and specifically e-filing in family law cases. We and NIJC use Odyssey eFile Illinois, which is a free filing service. To e-file using our CLSP form, you do have to create a waiver account. It's a very quick 30-second process to do that. But if you have any questions about e-filing, you can reach out to us. We do this on a daily basis and know the ins and outs. It's particularly confusing when you're first using it on how to get a court date. But like I said, we do it every day. So if you have questions, just reach out and we'll be able to guide you. So I guess I should talk about your initial filing, which is going to be the filing of your complaint, but then maybe more broadly, these cases in general, right? So these are custody cases. They're going to follow the same trajectory. You're going to file a petition or a complaint, just like you would initiate any lawsuit. Then you're going to serve the other side in some way. And after service, the other side has 30 days to file an appearance or answer to your initial complaint. If they don't, which we anticipate them not to in these cases, then you can move to default them and ask for an entry of a final order without their participation. Unique to family law cases is this idea of a prove-up hearing, which is a final hearing at which time your client will testify based on your questioning to establish the facts necessary to enter that final order. So your initial filing is going to be your petition. So you're going to meet with your clients today. You're going to gather relevant information. You're going to draft a petition. Your client's going to sign it. You're also going to draft a CLSP form that's going to be their fee waiver. That's going to be signed by the attorney handling the case. Domestic relations cases, divorce and parentage cases also require an affidavit of military service if you're planning on defaulting the respondent. And that's just an affidavit that your client signs swearing that the respondent isn't in active military service, as there are some protections that apply to military members. So none of these fathers, I assume, have any United States military service background given their background. So that'll be your initial filing. After you file your petition and all of these other documents, you're going to get an email back, or your firm's going to get an email back saying that your filing has been accepted. You're going to get a randomly generated case number, and then you're also going to get a calendar number. And we're going to talk a little bit later about what that calendar number means. But once you've got that case number, then you can move on to the next step, which is going to be service. In these cases, you're going to be filing a motion for service by publication, given that all of these fathers, I think you said except for one, reside outside of the state of Illinois or outside of the country. So in order to move to publish, there are certain documents that are required. An affidavit, two affidavits, one for service and one for kind of outlining your diligent efforts, which we'll talk about in a little bit. And as the slide says, reach out to me or to Phil, who's the Deputy Director at CVLS, for support with e-filing. Calling the clerk's office will give you a headache, and we can't help with any medication for that. So you filed your complaint, you've been assigned a case number, you've been assigned a judge through your calendar number, and the next step is service of process. Your general approach to service is, well, I need to serve the respondent in order for the court to acquire jurisdiction over him. If the respondent resides outside of the state of Illinois or outside of the country, you're going to have a difficult time arguing that the court can take personal jurisdiction over them because they lack any sort of minimum contact with the state of Illinois. So you're likely going to publish in these cases. You are going to publish in these cases. Or if the father is reachable, communicative, and willing to waive service, then you can do that. That's going to come from the information that you'll be given, as well as your interviews with your clients, as well as your client's willingness for you to reach out to a potentially violent respondent who lives in another country. But oftentimes that can be helpful if you can get a parent to sign a waiver of service, then you don't have to deal with asking the court for leave to publish. You'll already have the respondent consenting to the exercise of jurisdiction over them. So here are the most common service options. Typically, if you came to me with a family law case and you wanted to know whether or not you should publish or try to acquire or try to personally serve a person, I would tell you that you have an obligation to try to personally serve them first. Also, if you're trying to get other things other than custody or allocation, such as maintenance or division of property, if it's a divorce or child support, then you do need to personally serve, because that enables the court to get personal jurisdiction over the respondent. But if you're saying, well, all my client is interested in is an order of custody, and I can't find the respondent, or the respondent resides in another country and I can't get personal service, then if all you're seeking is that relief, that custody relief and these special findings, then publication is appropriate. And there are certain things that you must do, diligent efforts you must take in order to obtain leave from the court to publish. And the third option, of course, is a consent and waiver, making service unnecessary if the respondent signs. So I don't know if this is the case in the case list today, but you may run into a situation where your respondent is deceased, and like Dominique was saying, there's the ability to ask for abandonment findings on the basis of a deceased parent. One, okay. So generally speaking, you need both a petitioner or judges feel that you need a petitioner and a respondent or a plaintiff and a defendant to file these cases. We've gotten around that by asking the court to appoint something called a special representative on behalf of the deceased person. The Code of Civil Procedure gives you that ability. And instead of thinking about how you're going to serve a dead person, you're instead filing a motion to appoint a special representative to represent the interests of that deceased person. The special rep is usually an attorney that we recommend who has some domestic relations or probate background. Their role in the case is to see whether other probate cases have been filed. There haven't been, because this person doesn't usually reside in the United States. That person will file their appearance and ultimately support entry of judgment, because it doesn't impact the deceased person all that much, because we're giving custody to the living parent and then making these findings. If your case involves a deceased respondent, you're going to be following a kind of different trajectory than the other cases. So please reach out to us, and we'll recommend a pro bono special rep to take on that role and tell you how to proceed from there. So if you've successfully served your respondent and they have not filed an appearance or answer, then you may move for default by filing something called a certificate in motion for default. It's a standardized court form that basically just says, I filed my case, I've served the respondent, they've been given an opportunity to respond or appear and they haven't, and therefore I would like to proceed without them. That'll be usually in these cases your second court date. Your first court date will be to ask for leave to publish. Your second court date will be to move to default the respondent. And then your third court date will be this final hearing that we call a prove up. The slide says that a final hearing can be requested immediately if proceeding by consent. I think NIJC has not only a waiver of service form, but also a consent to the entry of judgment. Judges may have a problem with that. I don't think they've had to this point, but if you do just do a waiver of service, that gives the respondent additional time to appear or answer. If they live outside of the United States, it's 90 days. If they live in another state other than Illinois, they get 60 days. But just know that if you do a waiver of service, you'll still need to default, because the respondent has said, okay, I agree to the court exercising jurisdiction over me, and I agree to waive service, and then you're still going to default them after they've failed to appear or respond. If you're moving forward with a waiver of service and this consent to the entry of judgment, then you could go to your prove up right away, because you wouldn't need to default. So Cook County requires 2 hearing dates. Historically, you would file your certificate in motion for default, and you would appear in person in court to move to hold the respondent in default, and then your case would go to hearing on the final entry of an order instanter. Nowadays, we're on Zoom, and we require 2 court dates. The first to find the respondent in default. It's a very simple routine motion that judges hear all the time. Your Honor, we've filed our motion for default because the respondent hasn't appeared or answered. He's been served by publication. Please enter this order of default, and the court does. And then after the respondent is found in default, you can then file a motion for a prove-up hearing, at which time the court will enter your final order. If your case is not in Cook County, you might have to follow different steps to accomplish what it is that you need to accomplish. Prior to your default, your final hearing, your final prove-up, you'll draft a final judgment, which mirrors the petition for the most part. So you'll have drafted a petition alleging certain facts that support findings of abuse, abandonment, or neglect. And then you're also drafting a final judgment that you don't need right away, but you kind of work on as you draft your petition. So that judgment is necessary for your final hearing, because that's what ultimately the purpose of this case is to get that predicate order, which is your judgment. These are called an allocation judgment or an allocation of parental responsibilities and parenting time judgment. Custody judgment is what we used to call them. But in that judgment, you're going to have the following magic language that Hillary discussed earlier. The child's reunification with their parent or parents is not viable due to abuse, abandonment, or neglect under Illinois law, with the citation and a brief factual description. And it would not be in the child's best interest to return to their home country, and briefly state why. Because these are generally publication cases, you're going to be reserving any of the other issues that may have come up in a typical allocation case. Judges are familiar with these types of cases, the SIJS cases, but they used to not be. So you want to make sure that your judgment not only addresses this, which is necessary for the immigration issues, but also addresses all of the other typical allocation language that's required. So you're going to have to address the issue of child support. And typically, if you're not awarding child support, then you're reserving that issue. Issues must be either addressed or reserved in these final orders. So you're going to be reserving issues of child support. You're going to be reserving the issue of parenting time for the respondent, but everything else is fair game. If it's a divorce, then you're reserving the issues of maintenance, what we used to call alimony, and division of property and debt and things like that. So it's really important that you communicate with NIJC when you're getting ready to have this final order entered. Make sure that that judgment is reviewed by staff at NIJC so that it contains the language necessary to support the immigration case. Always make sure that your judgment matches what you've pled in your petition. Judges are usually paying attention. So make sure that you're not putting something in the judgment that wasn't initially asked for in the petition, and know that at your final hearing, you're asking your client to testify to certain things in your judgment. So make sure that those questions and the judgment are similar. So I'm going to be talking about some specifics in Cook County that might not apply to your cases that are outside of Cook, but in Cook County, when you file your initial petition, you're given a case number, a randomly generated case number, and then you're assigned to one of two calendars. There is a team calendar and an individual calendar in Cook County for domestic relations cases. You're either assigned a letter or a number. If you have a number, that means you're assigned to an individual calendar judge. And if you have a letter, that means you're assigned to a team calendar judge. The difference between the two systems is that in the individual calendar judge system, that one judge handles all aspects of your case, from your motion for service by publication to your motion for default to your prove-up hearing, which technically is a trial, although it's an uncontested trial, so it's relatively straightforward. But all those issues, all those steps of the case are handled by your one individual judge. If you're on the team calendar system, you are assigned a letter, C, D, or E, and all of your preliminary motions are heard by a team lead. And that team lead judge handles all of your preliminary motions. And then once you're ready for your final hearing or trial, then you move forward in front of one of the trial judges. Each team lead judge has 5 trial judges underneath him or her, and those judges handle final hearings and prove-ups. So typically these cases are going to involve 3 court dates. First, you're going to move to obtain permission from the court to publish against the respondent. You'll file a motion for publication and an affidavit in support of that. Like I said, the court requires you to take some diligent efforts, at personal service before moving towards publication. As soon as judges hear that the respondent resides outside of the country, they're more likely to grant your order for leave to publish, because there's no real practical way to personally serve a person in another country. So generally speaking, you want to file your motion for publication, but then you need to kind of paint a picture of the diligent efforts you took to get the respondent served, because some judges will want a pretty good explanation of those diligent efforts because it's required by statute, which can be a little bit weird, right? You're alleging perhaps that the father abandoned the child, but then the court is asking you and your client to take diligent efforts to locate that person who may have abused, abandoned, or neglected the child. And your client may be reluctant to do so. Your client also may find it strange that they're being asked to maybe contact a respondent who previously was violent with them or abusive towards them. And it's kind of a unique conversation to have because it's a requirement by the court that you take these diligent efforts, and you want to paint a picture that you've tried to get the respondent involved, but haven't been able to, and therefore you must publish against them. So typically this means talking to your client about how long ago they or the child have had contact with the father, what kind of steps they've taken to maybe include the father in the past, and how those efforts have been unsuccessful, whether or not they know family members or friends who are still in contact with the father. There are exceptions in situations of domestic violence where if your client is fearful of the respondent, then you don't have to reach out to the respondent in those situations. So just let us know of your specific fact pattern, and we can guide you the best way that we can.
Rob, I have a question.
Sure.
So there's 3 court dates. Does the client need to show up for all 3 of them?
No, the client's required to show up for the prove up because that's going to be your hearing where you're asking the client to testify to facts in the judgment. And they don't need to be there for the motion for default at all. And they typically don't need to be there for the motion for publication either. There are sometimes unique situations where the court wants to hear what steps the client has taken to get in contact with the respondent, but that's pretty rare. I would probably advise most of you not to have your client present at the first 2 court dates.
Are we publishing in like local publication or somewhere, like how if you're publishing notice, that's be in the country or we need the individual notice?
So it's published in a local legal newspaper called the Daily Law Bulletin. I think you have the ability to publish in any newspaper you want, but the court is set up to publish through the Daily Law Bulletin, and with our CLSP, it's free. So there's kind of a streamlined system for that. All right, so let's talk about that final hearing, which is your prove up. So I'm going to go through the timeline again. You file your petition. You serve the respondent. The respondent fails to appear or answer. You move to default them. The court agrees that they've not filed an appearance or answer and enters an order of default. Then you file a motion setting a prove up date because you want now an opportunity to have the court enter your final order. And you're going to file a very routine motion to set a date. And there are some unique things you need to do in the e-filing system to do that, and they're on this slide. But there are particular procedures to be filed for prove up. So 7 days in advance, you've got to send your courtesy copies to the judge and request an interpreter if your client needs one. And listed on the screen are all of the courtesy copies that you're going to be sending. And all of these things will be provided to you in advance, and you'll have prepared them so that they're ready. You've got your petition that you've already filed, your proof of service, so your certificate that publication has happened, your default order from your preliminary judge or from this judge that's already been granted, and then you've got a 28-day order. These are I've practiced in other counties, and other counties have some or most of these are similar. Judges typically require an order on prove up, which is just an order saying that the petitioner has 28 days to file a transcript of the proceedings. I guess it's important to note that your prove up hearing is going to be a hearing in front of the judge that's uncontested. Your client's going to testify to the facts that you've pled in your petition for entry of judgment. All prove ups that are by default require a court reporter. That's just a Cook County rule. So there will be a court reporter present, assuming you've done all of this correctly. and there will be a transcript of the proceedings that's available after the prove up. It's your responsibility as the petitioner's attorney to file a transcript of those proceedings within 28 days after the prove up. So if you're doing an allocation case, some judges don't feel like they need to do a prove up on allocation cases. I think we still would prefer to have a prove up hearing so that we can submit a transcript of the hearing in support of the immigration application. I think if you follow the kind of standard course and ask for a prove up, you might run into a judge that says, well, why do I need to do a prove up here? This isn't a divorce. This is an allocation case. Why don't I just enter your judgment? We're okay with that. And if it's particularly difficult to arrange for a court reporter and to have a hearing, then the judgment is all that really matters. That's the most important thing. The transcript is a nice, helpful addition to support the case. So.
And the reason that the transcript is important, if we can get it, is mostly for USCIS purposes as opposed to the family court. So if for some reason we submit that judgment to USCIS with the immigration petition and they send us a request for more evidence or they need to see something else supportive from the court, it is helpful for us to have a transcript of exactly what was said. But if we don't, we'll figure it out.
And then just going through some of these documents again, filed parenting class certificate. We're going to talk about this on a separate slide. A prove up sheet that's just a summary of things that are to happen at the prove up. Your proposed judgment, a court reporter information sheet that kind of summarizes everything neatly for the court reporter that's going to be taking down a transcript of the testimony in order for free transcript. As a CLSP attorney, you're entitled to a free transcript for your client and that military service affidavit that I mentioned earlier. So 48 hours in advance of this final hearing, it'd be a good idea to confirm with the court your request for an interpreter so that you don't show up and there's no interpreter and the judge uses that as an excuse to continue your case, or you're, as I was maybe, what was it, Kristen, like a few weeks ago, we waited about 2 hours for one. The day before or earlier, you want to make sure that you go over questions with your client to make sure the hearing goes smoothly. So, typical kind of, if you're ever going to have your client testify, not only do you want to make sure that they understand why they're there, you also want them to understand the questions that you're going to ask. And you also want to make sure that on the day of the hearing, you're only hearing answers that you expected to hear. It's every attorney's worst nightmare not to. So day of, you're going to log into Zoom, check in, appear on your case, follow the script. We have a script for, CVLS has scripts for allocation cases and divorce cases that go to prove up whether they're uncontested or by default. And you'll have a script specifically for the SIJS issues in your case. I believe this is the case in the collar counties, but at least in Cook County, all court dates are over Zoom, and everybody's gotten kind of used to it. So each judge in the Domestic Relations Division in Cook County has a Zoom courtroom with a meeting ID and a password. On the date and time of your court date, you're going to log in. And then depending on how busy that court call is, you're going to kind of watch and see how things go. Some judges who have a very busy courtroom will just start calling cases one after the other, and you're just going to have to be ready. Some judges want you to use the raise hand function on Zoom when you want your case to be called. Some judges want you to indicate on the chat when you're ready. So just kind of keep an eye on each judge's procedures. If you have a question about going in front of a specific judge or about a judge's temperament or something like that, then reach out to us and we can better advise. After you've done your prove up, so your client has testified, the judge finds everything in order and enters your final judgment, then you'll have to obtain and file a transcript of the proceedings. So the court reporter's office will contact you. You'll put your email on the court reporter information sheet. The court reporter will email you in about a week or two, letting you know that the transcript is ready, send it to you, and then you'll just e-file it into your case. So it becomes part of the record. So I mentioned earlier, parenting classes are a thing in Cook County. They're technically required by county rule. in all domestic relations cases. So whether it be a divorce or a parentage or allocation case, and even in default cases, they're required, which is kind of funny that you would have a parent who potentially is taking care of the child for their entire life. The respondent has not been involved at all and has abandoned the child, and the court still requires that petitioning mother who by this point probably knows how to parent quite well to take a parenting class because it's mandatory. A lot of judges won't care if they're not completed by the time of the prove up, but that is technically required. So we advise you to have this discussion with your clients. Some judges won't even do the prove up unless they see that a parenting class certificate has been filed. Not to worry, it's free. It's waivable. The fee is waivable with the CLSP. It's a 4-hour course online. It doesn't have to be completed in one shot. Your clients can come back to it later and continue from where they left off. They have to pass at a rate of about 80%, and it's available in both English and Spanish. I've had success asking the court to waive the parenting class requirement in certain situations. So if the court is asking for it, you have the right to ask for it to be waived. And if the court insists on it, then it's something that your client will have to do. But it's better to know this earlier rather than later so that you're not continuing your case.
So I want to step in because I think that we are almost at time to make sure that you all have time to grab lunch and start to meet with your clients. But I do think that these prove up hearings, Rob actually went into great detail about what's required in the prove up. Are there things from these last 2 prove up slides that you didn't already talk about?
I don't think so. Then if people have questions, they can always email us.
Yeah, so if there are there any questions at this point? Rob just put a lot of information on your plates. You will have a copy of this PowerPoint as well as a bunch of checklists and templates. But are there any larger questions that Rob can answer for you right now before we break and start to meet with clients? So we will also be walking around to your individual client meetings to see if there are any questions that we can answer as you're starting to speak with your clients after lunch. I do want to go through these last couple of slides because, okay, the immigration process, we've talked about that. When you're finished with your predicate order, NIJC will take over the immigration piece of the case, and we'll be in constant contact with you as well, and you can refer the client to us if they have any questions that are more immigration than custody related. But I want to make sure that we get to this, which is our first CLE word, wolf. Please write this down or take a picture so that we can ensure you get your proper CLE. So then our next steps are we're going to have a brief 20-ish minutes, maybe 15-minute break for lunch. And then we will break into groups where you will go into your assigned room and start to meet with your clients. NIJC staff will be available to walk around, as I mentioned, to check on you and see if you have questions. And then we will come back. No, this is a lie. I'm sorry. We have another whole section on working with clients before you meet with your clients. So we are doing a brief lunch break. Then we are coming back to give you some last tips on working with clients and meeting with clients, and then you will meet with your clients. Don't worry, there's a lot more information to come. Ashley, can I hand this over to you? We are just going to spend a couple of more minutes talking about these next logistical steps for meeting with clients and best practices for establishing your communication plan with them, which is going to be really important. So I'm going to scroll to our next section, and our coordinator, Berenice, is going to talk to you a little bit about next steps for working with clients.
All right, so just working with clients, you have to keep in mind how long you're taking with them. Some clients are coming from afar, and it's like really important to build rapport with them so they're familiar with who you are. And we did create a form where we put all of your names and your teammates. That way, if they have questions about their state court order, or if it's an immigration court, like, please bring them back to us, and then my name should be on there and other team members from NIJC who they're working with. And then again, in person is always good, but since these clients are far away, providing that transportation for them, or like even like a CTA card, that would be awesome. And then remotely, whenever we think that they're not able to come in, usually they work long hours, so kind of reading the room for them. Explain who you are. These clients might be the first time they're working with big time firms, so you guys are really important here. So establishing communication. Some of them don't have a phone line, so maybe WhatsApp if you have that, or other forms of communication such as Facebook Messenger if they are connected to Wi-Fi. Whatever you guys feel comfortable sharing with them, and Google Voice if that's a thing anymore, but it should be. Conference calls such as Zoom, and if they have a computer, usually kids have a computer at home, so maybe facilitating a Zoom call if needed as well. Again, establish phone numbers, a safe home address. Some clients have to move around because maybe they can't afford their rent, so, or they're like facing poverty. So it's establishing that safe address, sending a prepaid FedEx envelope for them. That's a great thing to do for them. Confirm the days and times. Obviously, NIJC has a standard of like 8:30 to 5. After that, do not call us, but if you guys need to call them afterwards, please establish a time with them. And let me see. Have clients sign signatures today. That way it's like easier and you don't have to send documents back and forth. So, and yes, next one. Always confirm that the client is being safe and they are in a confidential place to talk. Some of them are at work, and so they don't want to share their details about their case, or there might be another situation where you can hear them say, I can't talk right now. And then always be an active listener, saying, thank you for sharing this, or sorry this happened to you. Just being a human, that's what we call it. So yeah. Interpreters. So working with interpreters might take us long because you're using 2 different languages, and you always have to set time aside to get a hand of an interpreter. Today we have awesome interpreters in the room. Thank you so much for being here. And then you're always responsible for that, providing the interpreter. So NIJC staff or family members should not be interpreters, just because we want to keep that confidentiality. And interpreters, they're bound to confidentiality again, so they should interpret everything that is being said. Okay. And I do have another webinar on interpreters if you guys need more tips or a list of interpreters, but I'm pretty sure Kirkland has a big network of interpreters, so we're good on there. This is a reminder again that it takes twice as long. Next one. So we have to work on this hierarchy pyramid here. So we have to attend the client's needs at the bottom. That way you can attend the top ones. So again, clients might be facing poverty or house insecurity or their immigration status. They're very worried about that. They might ask you if they have questions like, what can you help me with an immigration case? But you can direct them back to us, and then we'll do everything as in our hands to help them or refer them out. And always, food and snacks, no matter your age or immigration status, is always like key. It can make a big difference if you guys provide them with those resources at the end. So any questions with working with interpreters, or any tips that I've learned that I can share with you? Yep. Okay, awesome. I think questions at the end again. So for today's meeting, Hillary's gonna go over that with you guys.
All right, here I am again. Just quickly, we are going to go through what you're going to get done today versus what you're going to start working on after your clients leave. So your clients are here to meet with you, to have those initial introductions, to sign whatever documents are available to sign today if possible, just to facilitate getting that taken care of. Today is not really the day for an in-depth interview, right? So we're not going to go in and be like, hey, tell me about your history of domestic violence or abuse and abandonment. This is our baby step, okay? You do want to make sure that they know who you are. Some of the clients, as Berenice said, this may be their first time working with an attorney. Others may have multiple attorneys right now because they may have immigration cases that are pending at NIJC. They may have an attorney for their child's asylum case, plus an NIJC point of contact. So expect some confusion. Try to anticipate that. Try to establish the boundaries of what you're going to work on with them and confirm their preferred contact information. You will, if possible, I don't know if Ashley, you were able to get signature pages for your petition. So at NIJC, we typically do this too, just to prevent future, headaches in terms of getting things signed. You will have the signature pages for your petition for custody printed out. Have your client sign that today, right? Don't put a date on it, but you'll then have a signature page for when you follow up with them to review your drafts by phone. We've just found this to be the most efficient way rather than trying to deal with the mail or FedEx or having the clients come in again. NIJC staff, as I mentioned, will be walking around to see if you have any questions in terms of this initial meeting. I think one last thing I would mention about the communication plan, just keep in mind, how should I say this? I work with a lot of teenagers, right? And what that means is they don't know how to use voicemail. Like I leave them a voicemail, they never return it. They don't know how to leave me a voicemail. They call me over and over and over again. They blow up my phone, right? And that happens sometimes. I try to set some boundaries around that. But what it means is that when I want to get a hold of them, I don't leave them a voicemail and then wait 3 weeks and assume that they have heard my voicemail and are eventually going to call me back, right? We're going to adjust our thinking about communication. If I really, really urgently need to get a hold of my client, I may call them 2 or 3 times in a row to just see if they pick up to communicate the urgency. I may text them multiple times to say, hey, please call me. And also it's urgent. And also here's who I am in case you have forgotten. So instead of using our polite attorney, limited follow-up communication styles, we are going to use our teenager communication styles. Questions about that? No. We're also going to the extent possible, get phone numbers for not only the client, but the client's next door neighbor, the client's grandma, the client's aunt, the client's cousin, to the extent that those are safe numbers, in case they run out of credit on their phone and we need to find some other way to get a hold of them. So getting more numbers is better, and it is going to facilitate you being able to stay in touch with your client. Okay. I mentioned already, they have multiple cases with NIJC, some of them, so you want to be real clear about who you are. We've provided a contact chart to facilitate that. So you can review that with the client and point to your name, your phone number, and make clear that you are the person to be contacted for this particular matter. We also will need you, if a new attorney comes onto your team, please let us know right away, because we have to update our contact information and our database. And then we'll want to make sure that the client knows who this new person is as well. All right, so what you have today that you will be reviewing with the client, in addition to those initial documents, you have a copy of their file with their baseline information. You have access to our one-pagers on SIJS. You will each have a template for the type of petition that you will need to file. This training today is recorded, so we highly encourage you to come back and review this recording if you have overall questions. And then as you have individual case-specific questions that come up, you will email your assigned tech support attorney, which will be either me or Dominique, along with Rob from CVLS. Although, as we've said, those of you who have cases outside of Cook County, we may end up having you be responsible for a little bit more figuring out of the procedures and then sharing with others in this cohort who have cases in the same county. Teamwork is helpful. This is the contact information for your tech support attorneys. Berenice mentioned, I know you all work on whatever schedules work best for you, right? And you're going to have some flexibility when working with your client if they do shift work or are in school or have, certain scheduling needs. I want to make sure NIJC will do our best to respond to you as soon as we get your email. We'll respond to you within 2 business days at most. We don't have big law office hours. So if you email us in the middle of the night, we probably won't email you back until our office hours, which are 8:30 to 5. Okay, flag for us if something is urgent because we will be there for you. We want to make sure that you have the best support for your case. But just keep in mind that these are the parameters that we're functioning under. Really quickly, the case timeline. So at the beginning, we mentioned that these cases can be completed in under 6 months. What we expect in terms of moving the case forward, barring anything unusual, is that today you're starting to meet your client, draft your petition, get those signature pages. Within 2 weeks, you should have those first drafts over to us. These, as we've said, these are template cases. They're uncontested. They're relatively straightforward. You will be plugging information into a template and reviewing it with your client. So NIJC will look for those drafts within 2 weeks, and we'll get them back to you with any comments within 3 days. And then you'll move to file right away, right? There are some cases where the child is going to age out and you have a more urgent need to move the case forward. Even for the children who are not going to age out, the faster we can move this case forward, the faster that child is able to take a step towards getting a work permit, getting some stability, getting protection from deportation. So we really do expect the cases to move forward in a timely manner, and we will depend on you for that because in custody court, the attorney is the one who moves the case forward. The judge and the clerks will not be checking on you to see how things are going. So take a look at this timeline. We've got timelines and checklists that have been provided to you in the materials, but just so that you know, this is a case you can get done quickly. It can be over with. You can have that sense of satisfaction and the child can move forward with their immigration petition. And now we've come to our last CLE word. Please take it down. This is point. And we will, after this, move into our client meetings.
Okay, a big thanks to NIJC and CVLS for all of